Hello and welcome to Broadband Deployment News. So the Second Circuit Court of Appeals, Federal Court of Appeals, has upheld a law that was passed by New York that would require internet service providers to offer a low-income product, a $15 product, to low-income households or families in the state. Ironically, the net neutrality rules that were just passed could scuttle that. Be right back with more. Thanks for joining me, Rick Husey, here with Broadband Deployment News. So you see here, this is in Broadband Breakfast. Federal Appeals Court upholds New York law setting retail internet rates, but is the New York law valid under the FCC's new net neutrality rules? So back in 2021, around April of 2021, New York passed a state budget, and in that budget, they had a rule that required any internet service providers operating in the state to offer a $15 product, a broadband product of at least 25 megabits per second to qualifying low-income households or residents in the state, and also a $20 product that would be 100 megabits per second. And about June or so, so right before it was set to go into effect, it was struck down by a state court judge, and then went to appeal. And as I say here in the Second District Federal Appeals Court, that was reversed. So now they're saying that New York could actually put this into effect, but they're also saying it could be problematic because of the net neutrality rules that were passed. So I see here, New York state law requiring discounted internet service for low-income residents was upheld Friday by a federal appeals court panel. The ruling dealt a setback to Republicans who want to preempt such laws, but also want a light-touch regulatory approach. So really, yeah, Republicans want the internet to be lightly regulated, as it's been throughout its history, and then also, as they would, I think, argue for any business, they would not want the government to be setting prices, what private companies can charge for their products and services. So that's part of that as well. Yet the court's ruling placed in doubt whether the New York Consumer Protection Law could survive under internet regulations adopted by the FCC on Thursday. And the court's opinion Friday suggested the FCC was now free to preempt the New York discounted internet law. It just upheld if it wanted to. In other words, the FCC could come in and say this isn't allowed under the new net neutrality rules that they passed. So in a 2-1 decisions, this was not the full. I don't think this was the full court if it's 2-1. Just a panel there. In the 2-1 decision by a panel of the U.S. Court of Appeals for the Second Circuit came a day after the FCC adopted net neutrality rules under the Title II framework in the Communications Act, and that's what the new net neutrality rules did. Originally, broadband was considered an information service or data service, I think it was, and by making it a Title II, it gives more regulatory power to the FCC, including the ability to do rate regulation. Now, the FCC came out in order to get this through, I think, and came out and said, no, we're going to forbear the ability to set rates. In other words, they said, even though we could have that ability, what we're passing here, we're specifically saying we will not be setting the rates of internet service providers. So that's kind of the crux of that. That's the tricky part here that could derail all of this. Under Title II, the FCC has far greater leeway to curb conflicting state laws than it does when it depends on the Title I in the same law to insulate internet service providers from state action. The New York City-based court's 55-page opinion was delivered by Circuit Judge Allison J. Nathan and signed by Circuit Judge Sarah A.L. Merriam. Circuit Judge Richard Sullivan dissented, saying the court lacked jurisdiction to hear New York State's appeal and that the New York State law, the Affordable Broadband Act, was preempted by federal law. Under Republican FCC Chairman Ajit Pai, the FCC in 2018 opted for Title I regulation of the internet, which in the court's opinion barred the FCC from regulating retail broadband fees on its own or from blocking states from mandating rate rules. In other words, under the way the Trump administration classified broadband under Title I, the FCC could not regulate broadband fees, but they also could not prohibit states from regulating broadband fees. So under those rules, New York would have been, I suppose, free to go in and put that put those rules in place. Although, again, it was going through the court process, and who knows what would happen or what will happen if this goes to the Supreme Court, if they would take this case up. But so that's kind of what's going on here, is that prior to the net neutrality regulations that were just put in, broadband was considered as Title I, and because of that, the FCC could not set regulations on pricing, but they also could not prohibit states from doing that. By moving broadband outside of the more comprehensive regulatory regime in Title II, the FCC surrendered the statutory authority to enact any rate regulations on broadband internet providers. The Second Circuit panel said, adding that the FCC had also abandoned its authority to preempt state regulation over broadband internet, basically saying the same thing. So that was under the Trump administration's classification of broadband. But Thursday's move by Democratic FCC Chairwoman Jessica Rosenworcel is unlikely to offer states the price regulation freedom they had under Pai's rules if Rosenworcel opts to crack down on state laws she feels are disruptive. This is not about rate regulation. No how, no way. We will not undermine incentives to invest in networks, Rosenworcel said Thursday at the FCC's open meeting in Washington, D.C. In other words, again, she was coming out and strongly saying that we will not be regulating prices. We do not want, and it's interesting that she says this, she says, we will not undermine incentives to invest in networks. In other words, saying that you're going to force internet service providers to, regardless of what their cost structure is, regardless of whatever, their business, to say that they have to charge a certain price for a certain product could certainly undermine incentives to invest in networks, because, they're going to, they could have less profit margin, which is what they use to expand the business. People think, oh, profit is bad, but profit is needed to be able to expand a business. That's how you expand a business, is with money that you get in addition to what you use to cover just your basic costs. You need additional money to be able to expand. But ISPs do not need to count on Rosenworcel's promises. The Second Circuit's opinion stressed that if the FCC forbears from rate regulation under Title II, states are not free to come up with their own pricing rules, meaning New York state law, the court just upheld, is probably unlawful. So again, because of what Rosenworcel said in her statement, but then also just the fact that there was an official forbearance of that, saying we will not regulate prices. It could be considered now that this is unlawful. The FCC decides to forbear from imposing a common carrier obligation. The states are prohibited from imposing that same obligation on the telecommunications service, the court said. In other words, if the FCC forbears from imposing a common carrier obligation on pricing, you have to price a specific product at a specific speed, or whatever, a specific price, then the states can't do that either. In the ruling, the Second Circuit reversed a lower court that had enjoined New York's Affordable Broadband Act, a law passed in 2021 requiring ISPs to offer service to eligible low-income consumers, priced at $15 or $20 a month, depending on the download speed. Again, $15 for a 25 megabit per second and $20 a month for 100 megabits per second. The upstream upload speed was not mentioned, and as I recall, in that. The law passed over industry objections that New York was encroaching on federal authority to oversee interstate communications and a 2018 FCC directive that barred state regulation of ISPs. But as the FCC has now found in at least two other federal appellate rulings, when the agency abandons Title II to supervise ISPs, it has also forfeited its authority to block states from adopting consumer protection laws aimed at ISPs. There is little doubt that when the FCC determines that a particular communications service should be subject to the heightened regulatory regime of Title II, it has the concomitant power to preempt state law that conflicts with its regulatory decisions, the Second Circuit said. In contrast, Title I grants the FCC no authority to impose rate regulations, nor does it contain a forbearance provision similar to Title II. In the opinion, Second Circuit did not say whether it considered the New York law to be rate regulation. That omission could be significant because the Rosenworcel FCC might not view mandatory low-cost plans to be impermissible rate regulation. In other words, it's not like saying you shall charge this price to every consumer. This is a plan for affordability for low income, so maybe the FCC would draw a line there, or try to draw a line there. Leading up to Thursday's net neutrality vote, public knowledge representatives raised that very issue with the FCC commissioner, or with FCC Commissioner Ana Gomez. The FCC should clarify that forbearance from ex post rate regulation. the FCC should clarify that forbearance, the FCC should clarify that forbearance from ex post rate regulation does not in any way interfere with the power of the FCC, state agencies, or other federal agencies to require providers to offer discounted affordability programs for those who qualify. Public Knowledge said in an April 18th filing with the FCC. For example, the FCC should not forbear from its authority to impose and enforce low-cost offerings to qualifying individuals as merger conditions or as conditions on subsidies. So those are two different things and not necessarily related to this New York ruling, because the New York ruling is across the board. Any internet service provider in New York, if this rule does continue to go through, is required to provide a $15 per month deal or a $20 per month deal, depending on the speed, to every low-income person, and doesn't have to do with whether there was a merger involved or whether this is they received some kind of federal or state funding through this. So that's a little bit broader. But the merger, for example, an example of that would be Comcast back in 2011, 2012, I think it was. Comcast, it's interesting, there's an ad right there for Comcast, merged with or acquired, really, I think it was NBC. So Comcast owns NBC, and as part of that, one of the requirements was that they had to offer a low-income product for 3 years, and they came out with their Xfinity Essentials product, which at the time I think was, what was it? It was, I think, 15 meg, a 15 meg product for $9.95. So basically $10, 15 meg. It's now a 50 meg by 10 meg product for that price, again, $10, or you can pay $30 for 100 meg by a 50 product. And interestingly enough, that was really only supposed to be in place for 3 years. So they were only required to offer Internet Essentials for 3 years, but it's still going on today. And they've, as I mentioned, they've upgraded the price and they've increased the number of people that can get it. Originally, it was just for certain households that had, I think, the free lunch program, and then they increased it to the reduced lunch program, and then they added maybe veterans and senior citizens and others have been added into this. So Comcast has actually expanded the program. $10 a month for $50 50 by a 10 product, or $30 a month for a 100 by 20 product. So this is something that Comcast, I guess, has found value in offering this. But again, that is a different situation where they were required to do this prior because of a merger. Again, 3-year limit, but they're continuing that. And then the other one would be, again, subsidies. So, and we see that with the BEAD program, for example. If you're going to get BEAD funding, then you have to offer an affordable product. And that's still kind of up in the air as to how that gets defined, because I think the government is trying to they understand the risk in saying that businesses must sell a product for a specific price, for a specific speed, that kind of thing. And that's going to be difficult just because the government really shouldn't be doing that for private companies. But then secondly, again, it's very different depending on where that product is, state by state, and then really also within a state. I mean, you've got some states that are very small, have lots of dense populations, and it's going to be a little bit easier for, they're geographically easy. There's not lots of hills, mountains, forests, those kinds of things. And you've got other states like Alaska or Vermont, where you've got very difficult, large spread out areas, or you've got territory, geography that's difficult, mountains and trees and whatnot that are in the way of getting your broadband to folks. And those areas are going to be much more expensive to deliver service. So in the BEAD program, it's been left more, I would say, it's kind of up to the states to come up with what would this low cost product be like. It's not necessarily even a low income product. It's a low cost product. Every provider should offer a low cost product, but what is the price and what is the speed? That's kind of left up in the air for the states to figure out, and then work with the NTIA and try to get that approved. So that's still kind of vague, and it's not the same as this, where it's a low income product. So, and all of this was kind of going on as the Affordable Connectivity Program was out there, and that's now, of course, about to be ending unless it gets the last minute reprieve from Congress to extend that. So, in fact, I saw something today or yesterday where there's a senator that is trying to get internet service providers to agree to go at least one more month. They're supposed to get partial payments in May, and they want the internet service providers to go ahead and do full payments in May to give Congress or whoever time to get a new ACP in place. So they're still pushing for that. So it's still potential that the ACP might, as I say, get a last-minute reprieve and be passed. But so affordable broadband, that ACP would be for low-income folks. What the BEAD program I believe is just a low-cost option. Not necessarily anybody could get it. So I don't think you necessarily need to be low income to qualify for that. I don't remember seeing that in the notice of funding opportunity. So we'll have to see what happens with this. I think the ISPs are trying to figure out what their next move would be. Do they appeal this to try to get it to go to the Supreme Court? Does the FCC get involved, and do they do something based on the net neutrality rules that they just passed? I don't know. So pretty interesting though, because I remember reporting back on this back in 2021, and I really didn't think it was gonna pass this bar here. I thought that the appellate court would be striking this down as well, because it is trying to tell a private company what products they can sell at what price. Now it is based on low income. It's not across the board, but still, I didn't think this was going to get through, but it has. So we'll have to see what happens next. Thanks for joining. I appreciate it. If this was interesting, if you could give me a like on the video, I would like that. And if you're not subscribed to our channel, click the subscribe button down there on YouTube somewhere, and you'll see a little bell. Ring that, and you will be notified when I am live. See you next time. Bye-bye.